Donald Trump's defense team demands a mistrial, saying that Judge Kaplan has allowed all sorts of egregious violations to carry on so badly that they justify throwing the whole trial right in the garbage. The letter came out from Tacopina, Donald Trump's defense team. It's 18 pages, filed on May 1st, and it gets sent over to Honorable Lewis Kaplan in the case of Carroll versus Trump. They say, Your Honor, Judge Kaplan, we respectfully submit this letter on behalf of Donald Trump to request that you, this court, grant a mistrial based on the pervasive, unfair, and prejudicial rulings by you, this court. Or in the alternative, correct the record for each and every instance in which the court has mischaracterized the facts of this case to the jury and allow Trump's lawyer to have a greater latitude to cross-examine Ms. Carroll and her witnesses. And we noticed this last week. When we were going through the cross-examination, we were quite surprised that there was so much interjection by this judge. In fact, Joe Tacopina himself said, I'm at a total loss, Your Honor. He was cross-examining her and asking her basic questions, and the judge was saying, hey, move on. We can all do math. We don't need to hear from you. Carry on. What are you doing? And even told him that I've already made my ruling multiple times and carry on. So the defense says a mistrial, Your Honor, should be granted because you, judge, you mischaracterized the evidence in favor of Carroll. You bolstered the testimony of Carroll, which we talked about. We said it was vouching, saying in that weird exchange that it almost reminded him of another novel. Something he's like, oh no, it's very much like a novel that I used to read. Supporting her statement against the defense. Also allowed Carroll to testify that Trump has 2 tables of lawyers at trial while prohibiting the defense from fairly clarifying the record by showing that Carroll has a comparable amount of lawyers. So while she was on the stand, look at that whole team of Trump lawyers, and she's only got 1 or 2 people at her table. Well, in the filings, there's a whole slew of people. They just didn't bring them into court. You also, Judge, continuously sustained improper argumentative objections. We heard those last week. Of plaintiff's counsel as to questions using a well-accepted looping methodology of cross-examination. You also permitted the testimony of Natasha without any voir dire of the witness when it's clear that her testimony does not follow the rules of the evidence and should be excluded. You also alluded to the potential use of United States criminal statutes as a remedy when Donald Trump's son, Eric Trump, posted something. And you remember when the trial started, Trump posted some stuff on Truth that the lawyers brought up to the court's attention. They were very upset about that. And then Eric Trump posted, and the judge said, this might be essentially, without saying it, this might be interference with the trial or obstruction or jury tampering, right? Pick a statute, pick any one of them. The judge was hinting about that. He said that you bringing that up in trial was castigating a completely truthful, and you also didn't allow non-prejudicial statements about Reid Hoffman, the billionaire founder of LinkedIn, who's funding this whole thing. Judge expressed distress with Trump's lawyer for bringing to its attention that someone on the plaintiff, Carroll's side, violated the court's order, which led to the worldwide publication of their jury trial results. Remember that Kaplan and her defense team, they put together a mock jury, and they tested E. Jean Carroll's cases in front of 3 of them, and 2 of the 3 found Trump liable for the allegations, and they leaked that to the press. And they didn't express any concern, the judge, that its protective order was clearly violated. So look at all of these things that have already happened. All of this is on behalf of Judge Kaplan, making decisions, making rulings, and changing the trajectory of this entire case. The defense continues. They said, Your Honor, you clearly mischaracterized the evidence in favor of Carroll with respect to surveillance cameras. You did not allow Trump to question her as to whether she even attempted to ascertain whether there was footage showing the parties together. Was there any camera footage? The Bergdorf Goodman store manager of the woman's store during the relevant time period, Cheryl, testified that, quote, she was certain that they had surveillance cameras at the entrance and the exits of the door. Somebody asked her in this trial, hey, Cheryl, do you have security cameras? She said, the only thing I can tell you for certain is I know that we had them at all of the doors. So if E. Jean Carroll's story is true, then her interactions with Trump on the ground floor should have been captured on video. And if a video existed, that would have significantly corroborated her story. It is Trump's position that her story is completely false and she knows it. Consequently, proof that Carol never attempted, never even tried, to determine if the footage exists constitutes circumstantial evidence that her accusation is false. Trump says that if she did not seek the footage of this attack, the reason she didn't go find it is because it never happened. Accordingly, Trump's counsel asked Carol if she made efforts to retrieve the footage. Miss Carol, you know there are cameras there, right? I think so. Did you ever try to go get the footage? The court shut down that line of questioning and alluded in front of the jury to the possibility that no such surveillance cameras ever existed, in direct contravention of the store manager who the plaintiff called in to testify against her testimony. When this question came in, it says, when you were allegedly assaulted by Donald Trump on the first floor and on the escalators with Trump, you never thereafter, that day, the next week, you never tried to get the videos that could have existed to support your claim. Mr. Ferreira says, I object to that, Your Honor, to the breadth of the question. Now, the court sustains this, and this is really an objection about, it's kind of like a compound question. It's very overbroad. The next day, the next week, you ever tried to get the videos? And it's like, well, it's really far, you know. And it's a perfect question, I think. But the judge overruled it or sustained it, right? They object, sustains it, so that question doesn't come in. And this is going directly to Miss Carol. Did you ever try to get the footage? We don't want her to answer that question. Objection sustained. Question goes out. So Tacopina goes, what? The breadth? Okay. The breadth of the question? The hell kind of objection is that? Okay. So they come back to the next question is the next day. He comes back. The breadth. So he narrows it up. So he says, okay, I won't ask about next week. Okay, I won't ask about the next ever, right? I won't ask about did you ever or the next day or anything. He says, I'll just ask you about this. Did you go back the next day, not the next month, week, year, to get the video footage if you have a problem with my compound complex question? The court says, sustained, sustained, sustained. It assumes there is such a thing. And Tacopina tells the judge, Your Honor, Miss Carol just testified, as did the Bergdorf-Goodman witness, that on the floor there are security cameras, Your Honor. And the judge said, well, Miss Carol testified that she guessed. And we have had testimony from the witness who was at Bergdorf at the time, and she said what she said, and we are not going to ask questions based on this kind of statement. Trump's lawyer says, Judge, can I ask this question? He says, I don't know yet. I haven't heard it. The judge, what? He says, I know you don't know it, so I'm going to ask it, and you'll let me know. So the question goes, Miss Carol, did you ever attempt to ascertain whether there is any video footage of you and Donald Trump at Bergdorf-Goodman? Objection. On what basis? Court says sustained. I sustained the objection to that question within the last 3 minutes. Hey, but what's the reason for it? You object to the breadth of the question, and then he's narrowed the breadth and says, okay, how about the next day? And then I assume there is a thing. Okay, but the other department store manager said there's footage, and Carol testified that she guessed there was footage, and the judge doesn't want to hear about it at all. The court also expressed to the jury that Carol could not have Trump prosecuted for the attack because private individuals cannot bring criminal charges, which was a wild thing to hear from this judge. He specifically told the jury when E. Jean Carroll was asked, they said, Miss Carroll, did you bring criminal charges? And the judge goes, you can't bring criminal charges. It's a civil case. And you go, duh, judge, it's a prosecutor. But the follow-up question would be, did you go to the police so they could bring charges? However, the line of questioning related to this issue and what the jury clearly would have understood from the questioning was the defendant's position that Carol could have gone to the police, made an accusation, which would have led to the prosecution of the charges. But she didn't do that because it never occurred. Trump was not trying to confuse the jury by implying that she could file a criminal case. That's not at all what we're arguing, Judge, and the judge knows that. Rather, Trump simply sought to establish that Carol's comment to Lawrence O'Donnell that she did not go to the police to seek a criminal charge because it would have been disrespectful to women being attacked around the world was a false excuse designed to conceal her real reasons for never bringing the charges, which is the fact it never occurred. Here's what the trial testimony sounded like. The question from Trump's defense to E. Jean Carroll. Ms. Carroll, according to you, you wouldn't bring a criminal charge against Trump because that would be disrespectful to women being attacked by the border and around the world? Is that what you said? Objection. The court says you already asked that question. Trump's lawyer says, I didn't ask that question. I played what she said. I'm asking a question about what she said. And the plaintiff, right, for E. Jean Carroll says, this is not a criminal case, Your Honor. And the judge sustained it. So Trump's team is getting absolutely railroaded here. I don't even know what the objection is other than, I guess, asked and answered. You already asked that question. I don't know. I didn't. This isn't a criminal case. Sustained. So Tacopina comes back. He says, all right, okay. Well, let me ask you this. How would you, now it's not a criminal case, how would you bringing criminal charges be disrespectful to the people at the border? Objection. And the judge says, sustained. He says, all right, that's it, counsel. He says, correct me if I'm wrong, counsel, but I believe in the state of New York, private individuals can't bring criminal charges and probably have not been able to do that in at least a century or two. And so scolding this defense attorney in front of the jury. And the defense attorney knows that, obviously, but he's being scolded in front of the jury. He's trying to bring up the point that Carroll didn't tell the police about it because it never happened. This is a red herring. The judge is using this opportunity to really take advantage of his position of power and scold the defense here. He says, no, they can't. They can't bring charges, but they could go to the police department. And he says, well, that's not what you said, counselor. We've been up and down the mountain on the question of whether she went to the police, so let's move on. He says, we have not been up and down the mountain of what we just heard. Can I just ask one question? He says, move on. That's what we get. Move on. He says, okay, I guess not. So the defense says, importantly, the phrase bringing our charge as opposed to making a report to the police was used by the defense counsel because Carroll, when interviewed by O'Donnell, discussed that exact phrase in the context of whether she would consider bringing a charge against Donald Trump. So do you see what the judge is trying to do here? It's very sneaky and it's not appropriate. But the question came in. You said that you can't bringing, right? The question, how would you bringing at any point, bringing? He's saying, counselor, you obviously can't bring a charge. And he says, I know, judge, but I'm asking her about her statement where she said, I was asked a question about consider bringing a charge. It's just mirroring her language. During the O'Donnell interview, clearly both O'Donnell and plaintiff herself understood, as lay persons would understand, that the reference to bringing a charge meant going to the police to file a report. Nobody thinks that that means you go in there and type up a civil complaint. I'm going to sue you when the jurisdiction. It's not that at all. But the judge is, oh, it's very technical and you're being dishonest to the jury. No, he's not. He's using her own language. Non-lawyers customarily use the phrase press charges when referring to going to the police to get a defendant prosecuted. Therefore, the court's hyper-technical interpretation of the phrase bringing a charge was made simply to protect Carroll from further cross-examination, resulting in unfairness to the defense. There was also a Jonathan Swift reference, which is the weird, we looked this up in the middle of the trial. When Trump's defense elicited testimony from E. Jean Carroll that her book contained a reference to all men in this country being sent to Montana, the court, in order to bolster her testimony, chose to essentially testify himself as to why such commentary was satire due to Jonathan Swift's work, quote, a modest proposal. Tacopina is asking Carroll, he says, okay, at one point in your book, Jean, I think you propose we should dispose of all men, something like that. And he's looking at the men on the jury. You want to dispose of all men? So are you a man hater or something? Okay. And let's see what happens. She said, into Montana. He says, into Montana? She says, yeah. And retrain them. Okay, so you want to, retrain. So all the men here in this courtroom, all the men in this country, all get shuffled off to Montana and all get retrained? She says, you understand that that was said as satire. He says, okay. And the judge says, yeah, Tacopina, it comes from Jonathan Swift's A Modest Proposal 700 years ago, right? And Carroll says, yes, it does, Judge. Very good. And they're playing this little game of patty cake in front of the jury. Totally inappropriate. So he says, let's move on. So the point of what happened with Tacopina about her wanting to emasculate and retrain all of the men is obliterated because the authority of the judge comes in and says, yeah, it's just like Jonathan Swift, the modest proposal 700 years ago, idiot defense lawyer. Right? Right, Miss Carroll? Is that true? She says, yes, it is, Judge. Okay, let's move on, Mr. Tacopina. He says, thank you, Your Honor. It's unbelievable. It's not even the appearance of impropriety. After Carroll testified that the above referenced notion of disposing and retraining of all men was satire, the court interjected in a manner that corroborated the testimony by stating such a notion was derived from Swift's book or poem or whatever. Rather than addressing the subject of men, Swift's proposal was to solve a problem of Irish poverty by killing and eating Irish children. That's what the book says, published in 1729. Solve the problem of Irish poverty by killing and eating Irish children. Isn't Joe Biden Irish? That said, if plaintiff wished to elicit testimony about a 300-year-old book that did not address the subject matter of her own book, she could have done so on redirect, meaning her lawyers could have come up here and talked about that. It was inappropriate for the judge to do so. It was not for the court to provide evidence from the bench to corroborate her testimony in a way that suggested favoritism to one party. Trump's defense continues, saying, Your Honor, also, during the defense counsel's cross-examination of Beale, who was the department store clerk or department store manager, I believe, and she testified, I think that was on day one. We don't have any idea exactly who she is, but Cheryl L.B. Beale, the department store manager, I think she was the first witness before E. Jean Carroll came out, says that during the cross-examination of her, the court further bolstered their position, saying to the jury that there was no one on the 6th floor at the time of the attack. Cross-examination back over to Cheryl. Says, here's my question, Cheryl. Given the proximity from the fitting room to the main area, if somebody, let's say, screamed inside the dressing room, would you be able to hear them from the main area? She said, well, if they screamed, I guess, yeah. I mean, depending on the volume, sure, we could hear it. The defense says, and if somebody's head was, and the judge cuts him off. Counselor, if a tree falls in the forest and there was no one there to hear, right? It depends on whether somebody is there, doesn't it? Mr. Brandt says, I got an answer, Your Honor. He says, I know you did, but let's not play this kind of game here. He says, I'm not playing a game, Your Honor. I'm trying to ask the witness questions. He says, you know where I'm coming from. We're all going, what are you talking about? No, we don't. Trump's defense continues. Whether the 6th floor of a popular New York department store was empty of all human presence at the time of the attack is a key issue, Your Honor. Thus, it was proper for Trump's defense to ask her about whether a scream emanating from the dressing room of the lingerie department could be heard. Carroll herself testified on direct that her laughter and her head hitting the wall was loud enough for persons nearby to hear. Question to her. Do you think, based on what you were experiencing in that room, do you believe that if someone had been nearby, they would have been able to hear what was going on in that room? She says, yeah, they would have heard the head hitting and definitely would have heard me laughing. Given these circumstances, the court's harsh admonishment of counsel for asking these questions was improper. As an initial point, opposing counsel did not even object to defense counsel's questioning. They don't care. The judge is objecting for E. Jean Carroll. Additionally, the jury could readily construe the court's commentary as a tree falling in the forest, as its view that no one was present. The jury could just say, yeah, nobody was there. That's why nobody heard her, because the judge told us nobody's there. And lastly, to the extent the court had any concern with the phraseology of a question posed, unjustifiably accusing the defense counsel of playing, quote, games in front of the jury, completely unfair. The court doing so again suggested favoritism of one party over another, all happening right in front of the jury. There was another comment about the amount of attorneys at the counsel's tables. The court, Judge Kaplan, also allowed Carroll to testify that Trump has 2 tables of lawyers at trial. And then the defense wanted to clarify that by showing that the record has on file a comparable amount of lawyers for Miss Carroll. And so the line of questioning goes like this. Well, one of the reasons Carol Martin told you, Jean, right, not to tell the story to anyone, one of the reasons you've testified that you never told the story because of Donald Trump's power, is that right? She said, yeah, I was afraid Donald Trump would retaliate, which is exactly what he did. That's one of my biggest fears came absolutely true. Says, okay. She's getting hysterical. He just lets her go. She says, he has 2 tables full of lawyers here today. It came absolutely true. Tacopina says, okay, Miss Carroll, we have the same amount of lawyers. Not everyone is a lawyer at the table, Miss Carroll, but regardless of that. And the court says, come on, Mr. Tacopina, let's move along here. Let's move along. He says, okay, yes, sir. I guess it's your courtroom. I guess we'll just move on. Now, the testimony about Trump having 2 tables full of lawyers conveyed to the jury the wrongful impression that she is disadvantaged in these legal proceedings. Couldn't be further from the truth. Testimony about Trump's lawyers is irrelevant and prejudicial. It risks evoking unwarranted sympathy to the plaintiff from the jury. But when the defense counsel tried to minimize that prejudice, the court interjected and expressed its dissatisfaction with that effort. Therefore, the court inequitably conveyed to the jury an endorsement of Carroll's view. There was an entire segment where Joe Tacopina was cross-examining E. Jean Carroll, and Carroll and her plaintiff's attorneys were objecting repeatedly, calling it argumentative. And we were having a difficult time parsing out exactly what the argumentative question was because we were reading a live thread, which we'll get to. But some felt argumentative and some didn't feel argumentative, but it's hard to understand because we can't read the full question and we can't see the full question really in the context of the entire chapter. And oftentimes we talk about direct and cross exams as a chapter. And so one question at the beginning of a chapter might feel argumentative, but it's going to be closed when you come back to the end of the chapter. So let's see how they talk about this and explain this. They say, by the way, Your Honor, and by way of continuously sustaining improper argumentative objections, the court has prohibited Donald Trump's lawyers from establishing a well-accepted method of cross-examination known as looping. This concept is based on evidence on the record, while argumentative questions are not. Once you get an affirmation of a fact or phrase contained in your leading question, the new fact can then be reinforced by the rhetorical device of looping. The new fact is used in the next question without re-asking the fact. By attaching the looped fact to a safe fact in the next question, while the who, what, when, and where is still important in the depo, these words should seldom be used during the cross-examination at trial. So he's saying looping is a tool, and he says, in this regard, it should be noted that Trump has a right to cross-examine. Here are some examples. The question to E. Jean Carroll from Trump's lawyers was, Ms. Carroll, it's your sworn testimony that Donald Trump waved at you across traffic, even though he met you only briefly at a party 8 or 9 years earlier and hadn't had any interactions with you since, correct? Objection. Sustained argumentative. Okay. Ms. Carroll, according to you, after Donald Trump saw you through a door, stopped you, supposedly recognized you after speaking to you for a few minutes 8 or 9 years earlier, he then asked you to help buy a present? Objection, argumentative, Your Honor. Sustained, rephrase. So do you see what he's talking about with this looping? He's bringing in the prior fact, which is Donald Trump saw you, stopped you, recognized you, spoke to you for 8 minutes, and then he asked you to help buy a present? Sustained, rephrase. The court made the same objection multiple times. Sustained, he said it's argumentative, it's repetitive, and it's inappropriate. So he said, so to be clear, Ms. Carroll, it's your testimony that even though at the time she wasn't your closest friend, you never confided anything like this before, you thought your first call when you left Bergdorf would be to her? Again, objection. Argumentative. Saying the judge should not have allowed those objections to be sustained. There was another segment here about Natasha Stoyanov's testimony. The preceding illustrations demonstrate the unfairness to Trump that has plagued these proceedings. One of the most glaring is the unfairness of the court's willingness to admit the unduly prejudicial testimony of this woman, Natasha Stoyanov. As Trump presented to the court, Stoyanov told Carroll in an interview conducted and recorded by Carroll that Trump, during the alleged Mar-a-Lago incident of 2005, 10 years after the incident, never attempted to touch her genitals or anus, which is required under the rules. And here, even E. Jean Carroll never disputed those facts. Stoyanov told Carroll that Trump, during another incident, 10 years after the incident, never touched her. And so therefore, Stoyanov's testimony amounts to extraordinarily prejudicial propensity evidence. Yet in order to support its admission, the court improperly resorted to bootstrapping other prejudicial propensity evidence. A lot of stuff here. Saying there's another, so basically they're trying to stack in all of these things unrelated to E. Jean Carroll's case. We're talking about the Access Hollywood recording. We're talking about Stoyanov testifying that Trump kissed her, which is not enough to get it in. Propensity evidence is this evidence that says that that if you did it before, you're kind of likely to do it again, right? You have the propensity to do a thing, therefore you did it here. The fact that the court in the first place needed to engage in bootstrapping to admit this testimony highlights this testimony's lack of probative value. They did not even conduct a brief voir dire of her before admitting it. They say here they're also alluding to extrajudicial remedies. Remember when Donald Trump and his son put out a tweet before the trial? They were talking specifically about Reid Hoffman funding the litigation. Initially, it was posted on the tweet. Hoffman admitted to funding this lawsuit. He posted on LinkedIn. He said, in addition to E. Jean Carroll, grantees I have supported include the following people. So it's not a secret. Everybody's talking about it publicly. It's also not disputed that Hoffman has no direct involvement in the case. He is launching a number of efforts to boycott Trump and to stop him from gaining the White House. Therefore, Your Honor, there is nothing wrong with Eric Trump posting whatever he wants. Nonetheless, the court issued some threats. He said, I said something this morning about your client, perhaps now sailing in harm's way, conceivably with his son, if the report I heard is just true. That came out from the judge. Your client, Trump, and his son might be in trouble. Remedies might be available from this court may not be the only relevant remedies. If I were in your shoes, I'd be having a conversation with the client saying, Trump, I'm going to refer this over to the DOJ, and this is going to be in their purview. And if they want to add another prosecution, they can do it. Eric Trump isn't before me. He says, I'm simply suggesting to you, lawyer, that there are some relevant statutes here. Now, although the court didn't identify those statutes, the notion that any statutes would be appropriate to impose a remedy for a tweet is highly inappropriate and incendiary. Eric Trump is free to post what he wants. Consequently, the court's comments in this regard reflect a predisposition, which is the unfair treatment of Trump. Now, there were other situations where the court was scolding the defense. The court has already accused the defense counsel of, quote, playing games in front of the jury, said that to the defense in front of them, based on a line of proper questioning. It expressed no concern about how somebody from Carroll's side violated the court's protective order to leak data to the press. Tacopina told the judge, Your Honor, the jury's been instructed not to read the media, so we can assume the jury's not going to violate the order. But he says, first of all, let's put things in context here. A week ago, right, so the jury's not going to violate the order, so they're not going to see Trump's posts, right? They're not going to read anything about this case, Judge. So just relax. Trump can post whatever he wants. Jury's not reading anything. They're following your orders, right? Okay. Says, but I will talk to him. A week ago, before this trial started, there was an article which I read yesterday in reference to a leak. Not from Ms. Kaplan or her office, of course, but somebody leaked that 2 mock jury trials have come to a conclusion finding liability. Now, you talk about prejudicial before a week before trial. I think that's pretty much the pinnacle of prejudice. The judge says, but you say you're not accusing the plaintiff's team of having done that. He's, no, I'm not accusing her specifically or any of the lawyers on that team, but somebody from their side did it. Whether it was a jury consultant or one of the jurors, I don't know. But somebody from that side leaked it. It wasn't us. I'm being consistent with the court's desires here, Your Honor, and I've got a great deal of respect for Ms. Kaplan, and I like Ms. Kaplan. I'm not suggesting that she would have done that, but someone from that world over there, they leaked it. The judge said someone from that world may have been somebody that was picked up off the street and offered whatever they offered these days to sit for a day and leave. Now, you know how those things work, and you're trying to pin it on the plaintiff. He says, no, I'm not, Your Honor. It's impossible that they knew about other juries and other juries. It was not a person that was on the jury who didn't sign a protective order, by the way, and just left. This individual, if you read the article, which I just read, he says, I read it too. It says that there were 37. If I have the number right, people brought in, and 37 were all. In one place at one time, they were divided into 3 groups. He says, yeah. Every person in there knew they were in 3 groups. He says, yeah, but every person, if they were provided 3 groups, would have known what the other jurors came to as a conclusion, I was imagining. Hopefully that was protected, right? The court says, Mr. Tacopina, I have a good imagination too, and I can imagine you're right, and I can imagine that facts are entirely different. So as set forth, instead of saying a single word to the plaintiff's team for violating the order, he challenged the counsel. He says, are you just making this stuff up? I have a good imagination too, just like yours. The circumstance speaks volumes about the court's treatment. So they're asking for some relief here. They're saying, while the defendant recognizes the court has discretion with respect to evidentiary matters, there comes a point, Your Honor, where the cumulative effect of your one-sided rulings manifests a deeper leaning towards one party over another, meaning you're biased against Trump. Moreover, such a finding is buttressed when the court openly expresses favoritism in its remarks. Here, despite the fact that trial has been underway for only 2 days, the proceedings are replete with numerous examples of unfair treatment. Therefore, Trump requests a mistrial. The relief is only appropriate where there's a manifest necessity for the order, and there is here. In the alternative, in an effort to salvage these proceedings and level the landscape, we respectfully request the court correct the record in every one of those instances outlined above. And if this trial does proceed, we ask the court allow defense counsel greater latitude to do our jobs. In a similar vein, so as to enable Trump to fairly defend against these accusations, defense counsel should be permitted to cross-examine her about third-party litigation funding, now that she's opened the door on her direct examination. There was another case. However, following a court decision in another case, plaintiff testified at trial about a Democratic operative. The question for Carol was, what did you sue Trump for? She said, defamation. Why? Well, because he called me a liar. Because he said that I had accused other men of attacking me. He said I was an operative or in a conspiracy with the Democratic Party. He said I was trying to sell a book, so I made up the story. And he said I was too ugly to attack. So I sued him. Another question was, how is Donald Trump different than Les Moonves? She says, well, because Les Moonves was another man who allegedly attacked her. Why aren't you suing him? Well, here, Donald Trump called me a liar. Is that it? Or is it because you guys on this side of the aisle, the Reid Hoffmans, the George Conways, all of the people who are instituting lawfare against their political opponents, they like this plaintiff because she can go after Trump. Les Moonves can't. He's not running for president. She said Donald Trump called me a liar, said I was pulling a scam, said I was a con, I was running a con, that I was a Democratic operative, that I'd accused other men of attacking me, that I was in it for the money, that I was in it for the attention, and Les Moonves stayed quiet. That's why he avoided her wrath. Okay. Now, given that plaintiff, E. Jean Carroll, through her direct testimony, has affirmatively accused Trump in this case of defaming her for being a Democratic operative, she has now opened the door to the litigation funding. She's being funded by Reid Hoffman, a Democratic operative. Consequently, in order to defend himself against the accusation, Trump should be allowed to ask her about this during cross-examination because she brought it up. You say you're not a Democratic operative? Maybe we'd like to present some evidence about that. Therefore, Joe Tacopina says, based on the reasons above, the defense respectfully requests the court grant a mistrial in this case, or in the alternative, correct the record for every instance and allow defense counsel to cross-examine E. Jean Carroll and do their job. We thank the court for its consideration. Respectfully submitted, Joseph Tacopina, going directly to Judge Kaplan. And as you saw here in this beautiful document, they've articulated all of the various injustices that we have observed and covered here as we have been following this trial along. The judge is not going to like this. He's going to think to himself, everything I've done is perfectly legal and appropriate. I'm a judge. I've been doing this for decades now. And who are these people to tell me what to do differently? And so, of course, we'll see how this unfolds in trial and whether Trump succeeds.